Good morning, everyone. Thanks for joining us for the June installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you as prior participants know, we do these on a monthly basis as a quick update on timely and interesting issues in environmental law. Our goal today is to update you on the latest developments concerning Section 401 of the Federal Clean Water Act. This is the section governing state water quality certifications. I am Kevin Ewing, and I'm joined by my colleague, Christine Wyman, and both of us will be walking through some of this with you. If you have questions as we go through our presentation, please type them into the comment box on your screen. We'll get them in real time, and we'll get to as many of the questions as we can. If we run out of time, of course, we'll be happy to respond to questions in follow-up emails. First, a quick refresher on Clean Water Act Section 401. That's the section that prohibits federal agencies from issuing final permits until after affected states have a reasonable time, up to 1 year, to say whether the project under consideration will comply with applicable water quality standards. If a state denies the certification of compliance, then the federal agencies are forbidden to issue the permits. On the other hand, if states conditionally or otherwise certify the compliance, the federal agencies must include the state's conditions in their federal permits. That's the basic scheme. In the last few years, though, several major interstate natural gas pipeline projects and other kinds of projects have been stymied when certain states have used the Section 401 authority to deny certification, sometimes on grounds that stretch the limits of Section 401, to put it charitably. For example, denying a 401 certificate because of inadequate analysis of greenhouse gas emissions, clearly not water quality related. The Trump administration has taken active steps to promote infrastructure development generally by streamlining federal reviews, and the administration is now taking a close look at Section 401 in particular, and that's what we wanted to update you on, what's been happening in that field. Christine?
Great, thank you, Kevin. So in April of this year, President Trump issued a set of executive orders focused on energy infrastructure permitting. Executive Order 13868, Promoting Energy Infrastructure and Economic Growth, builds on prior EOs to encourage the timely and efficient build-out of energy infrastructure. Unlike prior EOs that provided the framework or principles for implementing federal environmental reviews, this new executive order identified specific topics for improvement, including improving implementation of Section 401. The EO provided a roadmap for federal agencies like EPA for improving Section 401 implementation. It requires EPA to review its existing 401 regulations and guidance on key aspects of the 401 program. It requires EPA to consider issuing new guidance, which they just did, and it also requires them to consider issuing new regulations. In doing all of this, the EO requires EPA to consult with the state, tribal, and federal officials. The executive order also recognizes that there are several federal agencies involved with Section 401, the agencies that are actually implementing Section 401, and that there is value in Section 401 being implemented consistently across federal agencies. To this end, the executive order requires EPA to convene an interagency working group on Section 401. And it also instructs the other federal agencies to consider issuing new guidance and regulations that are dovetailed with the EPA actions. In doing all this, the executive order directs particular attention to 4 problem areas. First, what is the proper scope of state review and how broadly can states apply their laws to deny a certificate? Second, what is the proper scope for state conditions on certification? Third, what is a reasonable amount of time in which a state should act? And fourth, what information must an applicant supply to the state? The President's timeline for the action under the executive order is brisk. The EO was issued on April 10th of this year. EPA's new guidance came out on June 7th. It was immediately followed by commencing the Interagency Review Working Group. On August 8th, EPA is expected to propose its new regulations. September, federal agencies must update their own guidance to reflect the concepts from EPA's new guidance. By May of next year, EPA must issue final regulations, and by August of next year, federal agencies must start revamping their own regulations to match EPA's. The schedule appears designed to avoid the clawback risk under the Congressional Review Act, which allows Congress to kill regulations, which is a concern if Democrats take back the White House and Congress in the 2020 election.
So EPA did hit the target date with this new guidance, and so that timeline you just saw, which sets forth a number of actions, is off to a timely start. The guidance came out on June 7th. It's quite a document. It's clearly very carefully crafted, and it's also bold. In the guidance, EPA takes several important steps, while I think also foreshadowing to a certain extent additional steps that it's not taking now, but that it might intend to take in the form of notice and comment rulemaking properly under the Administrative Procedure Act when it proposes its new rule. So when we look at the guidance, we can both see what it's doing now and maybe see what might be coming down the pipe. In the guidance to date, EPA has rescinded its earlier interim guidance from April 2010. This was a handbook, as it's often called, that caused significant problems by according states more authority than the statute and case law actually authorized. It was an interim guidance that was never finalized, but it was used as though it were gospel and certainly used as though it were final, and it's now been formally rescinded through this new guidance. EPA also directly addressed key trouble spots that some states have exploited to block projects. I think both those kinds of actions were much needed in this guidance. If you turn to the old interim guidance, this is the cover page of that 2010 guidance. It isn't all incorrect, but it certainly has elements that are in tension with the statute and with case law. The old EPA 401 handbook, which, as I said, has just been rescinded, expressly endorsed, for example, the notion that the state's review period does not start until the state is satisfied that it has received a complete application. Some states have used this point in the EPA guidance to justify endless rounds of sort of supplemental and amended applications before being willing to start the 401 clock that runs out or after a reasonable period of time, not to exceed 1 year. That practice was never legally sound, but it seemed to be endorsed in the guidance, and it was finally tagged as not legally sound recently by a court decision in the Second Circuit last year. Second example, the old EPA guidance seemed to encourage states to pressure applicants to withdraw and resubmit their 401 applications when the clock was winding to its end in order to restart a new period of time not to exceed 1 year. This resulted in multiple year-long periods that frankly evaded the statute's clear 1-year time limit under Section 401. That practice too was tagged as in violation of the Act earlier this year in the important Hoopa Valley DC Circuit case. So these are just two examples where the handbook seemed to confer extra legal authority that some states were using to stop projects inappropriately.
So besides rescinding the old EPA 401 handbook, the new guidance does much more. It really is a very well-crafted and a lot of nuance and thinking went into the guidance document to ensure that the guidance is aligning with the statutory principles and recognizes a lot of the new case law that we have on Section 401. So some of the things that EPA has affirmed in its new guidance we deal with the start of the time period for the clock as well as some of the waiver provisions. So first, EPA confirmed that it is the federal agency that has the authority to determine the reasonable timeline for state review and that it will not exceed 1 year. This is important because in the past, states have there has been a desire for the states to control when the time period begins, and there's also been a suggestion that it is always 1 year. So EPA has confirmed that that is not the case. This actually dovetails with the president's executive order on one federal decision, which suggests that it's the lead agency that is the driver's seat for permitting schedules, and that is what we're seeing here in Section 401 as well. Second, the EPA guidance suggests that the 401 clock begins when the application is received, not when the state deems it complete. This is another important concept that will make meaningful changes in the way that 401 is implemented. Recent case law from the Second Circuit has just clarified that it is not the states that deem an application complete, and that is not when the state, that is not when the time period begins, and that is not a triggering action. And so the The receipt is when the time period begins, and EPA has confirmed that. Third, withdrawing and resubmitting the same application does not restart the one-year clock. As Kevin just mentioned, that was a practice that many states had engaged in, endorsed by the EPA handbook, to evade the statutory time period for review. The DC Circuit in Hoopa Valley confirmed that that is not a way to restart the time period, and that actually isn't, takes the authority away from the federal agencies that are tasked with implementing these federal permitting reviews. And so EPA has confirmed that that does not restart the one-year time period, and that states should act within the reasonable period of time as defined by the federal agencies. Fourth, the EPA guidance confirms that the federal agency decides when the reasonable period of time has elapsed, and therefore when the requirement for a Section 401 certification is waived if the state has not acted by then. This is important because states in the past have claimed that they have the authority to waive their Section 401 authority, and that is always the case. The state can decide not to act on a Section 401. But what the guidance in the case law has made clear is that it is the federal agencies that determine when a state has not acted. And when a state has not acted, the federal agency is to determine waiver and move forward with processing their permits. In the situation where there is a lead agency and there are multiple federal agencies reviewing a project and are awaiting that 401 certification, the lead federal agency makes the waiver determination, and all other federal agencies are to then go forth and process their permits. In addition to timing and waiver, EPA's guidance also addresses the scope of the state's review and makes clear that it focuses on water quality. This comes up in a couple of different instances. First, in the state's decision to grant or deny a certification request in the first instance, the state is to look at potential water quality impacts. Second, in the situation where a state has decided to grant a certification because they believe that the discharge can comply with the water quality requirements, 401D allows states to condition that certification. Those conditions must be based on the enumerated provisions of the Clean Water Act, as well as any other appropriate requirement of state water quality law. Bringing back the state's review and tying it to water quality is a return to the basic principles of Clean Water Act and the statutory principles enumerated in Section 401.
So you should by now have a sense that the guidance is a pretty substantive document. Substantive in the sense that it tackles real issues, and it does that with clarity and a measure of boldness. What it does not do is step beyond the bounds of guidance into notice and comment rulemaking. So there are other topics, or even the same topics, that can be treated to a greater degree through APA action and a proposed rule. So the new EPA guidance is not the last step. We know that. It was set out in the President's EO that there would be a multitude, a sequence of actions being taken. EPA is slated to issue a proposed regulation by August 8th, and they're busily working on it. In fact, they're working hard on writing it as we speak. We anticipate that EPA will substantially update Part 121 of the Clean Water Act regulations, but that will be the locus in the Code of Federal Regulations for the changes that they propose. The proposed rule may anchor certain points that are reflected in the guidance while also going beyond the guidance to tackle some issues. We don't yet know what the proposed rule will say in its entirety, but we might anticipate that it would address topics like what information is enough to constitute a request that starts the 401 clock. This is sort of the counterpart to the idea, well, if there's not going to be, if the clock is not going to await the state's determination of application being complete, then what constitutes the application? What constitutes the request? What is enough to be a request? And who gets to decide that? Those are issues that are not yet fully addressed in the guidance and might need to be tackled in the regulation. Other questions relate to, well, what happens if a state imposes a condition on its certification, but the condition lies outside the proper scope of 401 review, outside the scope of 401D or otherwise? Does that make the whole certification under 401 invalid? Does it make only that condition invalid? and the rest of the certification is still active, who gets to decide that? What's the federal agency to do? Given the recent turmoil and perhaps even excesses by some states in taking action under Section 401, the return to a balance of yore may feel like a constriction to certain states and stakeholders. Wherever this ends up going in the proposed rule, the guidance is sufficient already to have stimulated a certain kickback in statements and letters of concern to the agency. And it, I'm sure, anticipated some of that. There's a fear out there among some, and some others are fomenting this fear, that there is an effort to do a state power grab by the feds, to grab power away from the state that Congress had intended under 401 to give to states. I don't see that in the form or the balance or the emphasis in the guidance. We'll have to see how the proposed rule looks, but for the moment, it appears like it's more a return to a state of balance in the federal-state balance of power and comity that under which the section worked very, very well for decades. So EPA's efforts with the guidance and the proposed regulations are likely to be challenged. They're likely to be challenged in the court of public opinion and probably challenged in court under the APA and otherwise. It appears so far that EPA is working hard to ensure that the actions that it is taking achieve their streamlining objectives, which are the President's objectives, while adhering to the legal requirements of the statute and honoring the federal-state comity and cooperative federalism that I think the administration prizes highly. So that is a quick run through what's been happening of late and what might be coming up. We have some questions that have percolated, and let's see where they take us.
Right. So the first question that we have is, what impact did the guidance have on pending litigation?
You mean there's litigation on this topic? Well, there's a lot, and I have to preface it by saying I can't answer that in relation to any particular company or any particular piece of litigation. But courts have afforded deference to federal agencies when they are acting within the scope of their authority under a statute. That is, agency deference is a longstanding a statutory commitment in the APA and in fact precedes the APA. So when you think about it, the guidance is the statement of the authoritative federal agency with respect to Section 401. And that means it should be accorded deference if and when it gets argued for support in any particular case. We'd expect the guidance to be afforded particular consideration by the court. FERC's reconsideration of New York's denial of the Constitution pipeline certification could provide an opportunity to offer EPA support for the concept that the withdrawal and resubmission does not restart the clock, for example, because it seems to dovetail with the Hoopa Valley decision that we were provided by the DC Circuit earlier this year. So I guess I would conclude by saying, without reference to any particular case, the guidance alone could become additional indicative support for briefs and arguments being made in several different cases as the expression by the authoritative federal agency charged under the Water Act for interpreting and applying the 401 program. Probably that will have a greater effect when proposed rules are made final in the same vein as the guidance, but the guidance alone may afford some toehold and certainly a point of discussion in court papers, is my sense. Christine, what do you think?
I think that's right. I think the deference that courts have afforded to EPA, we've seen that play out in the case law already. FERC's decisions on Section 401, as well as the Army Corps of Engineers' decisions on Section 401, when these decisions have been challenged in court, the courts have been clear that they do not receive deference on the interpretation of the Clean Water Act and implementation of Section 401. In contrast, courts have cited to EPA's implementing regulations found at 40 CFR Part 121 and have given them deference for interpretation of implementation of Section 401. So to the extent now that we've got EPA statements coming out in guidance that will be acted upon by federal agencies. I think that will help federal agencies in their actions and getting more deference on those, tying it back to EPA.
Yeah, I think that's right. And here's a related question. Is the guidance going to be challenged in court? Well, maybe we'll even expand that. Is the guidance and the regulation to come going to be challenged in court? I think we prefigured that that's likely. What do you think, Christine?
I think that's exactly right. The guidance, I think, will be challenged. We've already seen some commenters. EPA had a docket open on kind of a pre-proposal considerations for Section 401. The docket was in advance of the guidance coming out, but many of the commenters from some state organizations as well as some other environmentally minded organizations suggested that the guidance, because EPA was not taking comment on it, was going to be running afoul of the Administrative Procedure Act because it is tied to the executive order. And this is the argument that they have made, is that the executive order has directed EPA to take action. EPA's action is and discretion is a little foreclosed in what they can do because of the executive order, and therefore they should have taken comment in advance of the guidance because it's more of like a rulemaking. And so I would expect to see some litigation either over the guidance directly or definitely, as Kevin suggested, once the regulations come out.
I think probably it's easier to attack a reg once it's out than a guidance, especially one as circumspect as this one. But in the war of ideas, one sometimes launches challenges just for the sake of the publicity around it and to begin to create a context for decisions. So we may see a challenge to the guidance.
That's true, and even I think we saw that with the executive order that came out as well. There was a lot of remarks that some of the states that did not agree with some of the content of the executive order had expressed in the news some intention to file challenge over the executive order. So there's a lot of newsworthy statements being made about this.
I think that's right. Here's a question that I think is quite interesting. What happens when a state imposes conditions outside essentially the proper scope of 401? Is the whole certification invalid? What happens? I touched on that briefly a few minutes ago, but it is a complex question, and EPA's guidance actually begins the answer to it. In the guidance, EPA suggests that federal agencies work with their own general counsels at the federal agencies or consult EPA to evaluate the validity of the state's action in imposing that particular condition that is at least subject to doubt. I think if we reflect on that for a moment, consulting EPA about the validity of a particular condition to a certification has, I think, some real merit. For one thing, the EPA is the authoritative voice among the federal agencies as to how the program is to be administered, and in particular what it means, and what is within scope and what is outside scope. We already have case law that makes it difficult or indeed restricts permitting federal agencies from picking and choosing conditions that the state imposes in a certification, and that's not kosher. But the idea of a federal permitting agency saying, hey, we're uncertain about this, not picking and choosing, but raising the yellow flag, and then going to the federal agency charged with administering the program, that seems to me to have some merit and may get greater judicial deference if challenged. So we'll have to see how that idea, which is in the guidance, ends up being incorporated or not, or even elaborated on or not in the proposed rule.
Yeah. And to that point, the EPA's ability as the implementer of Clean Water Act and having more deference on their actions, EPA actually implements Section 401 when it comes to their NIPSES permits under Section 402 of the Clean Water Act. Right. And for a long time, EPA's regulations on this matter have required the states to follow a process in providing the regulatory support for the conditions that states are imposing and the conditions on the NIPSES permits. And EPA's process has been that if states do not provide that justification, EPA does not include that condition in the final permit. And so there is precedent for EPA taking these actions and using their deferential authority
I would say
Yeah.
present in the form of analogy,
Yes.
but a very close
Yes.
analogy under the NIPIDs program, which is the wastewater discharge program. I think that is probably a very good analogy, so I'm glad you raised it. So we'll have to see how that plays out, but I would imagine that it would be somewhat consistent with what EPA has already been doing successfully under another program. Let us see if there are any further questions. Give you a chance to type them into your comments. Otherwise, we may be able to give back to you a few minutes of your Tuesday morning. We very much appreciate your joining us.
Yes, and please do tune in next month for our regular Environmental Essentials webinar that we hold. Next month will be titled Environmental and Natural Resources Laws, Changes Affecting Infrastructure and Energy Project Execution. This discussion will focus on the latest developments in the Trump administration's efforts to streamline federal permitting and simplify requirements under an array of federal statutes.
That really is going to be a great program. I encourage you to come and listen to that and ask questions, because it's going to cover, unlike this 401 presentation, a much broader array of efforts to kind of take stock of where we are 2 years into the administration's efforts. Thank you all for joining us, and we look forward to speaking with you and seeing you in the time ahead.
Thank you.